rise. The Honorable, the Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court now in session.
Please be seated.
Madam Clerk of Court, please call the cases before us.
Good morning, Your Honors. This is a continuation of the oral arguments on the consolidated petitions in GR number 271059, Representative Edsel Lagman, as substituted by Albay, 1st District Representative Crisel Lagman et al. Versus the Congress of the Philippines et al. GR number 271347, Aquilino Coco Pimentel III and Pantaleon Bebot Alvarez versus Lucas Bersamin in his capacity as Executive Secretary et al. GR number E-02472, Filipinos for Peace, Justice and Progress Movement Incorporated, or FPJPM, as represented by its President and Chairperson, Joseph F. Cadsawan, and Chapter Officer, Gloria T. Puzon, versus House of Representatives et al. And GR number E-04036, Edgar Erice and Laila de Lima versus the Senate of the Philippines, represented by Senate President Honorable Vicente Soto III et al. Thank you, Your Honors.
Appearances for petitioners, please.
Good morning, Mr. Chief Justice, Senior Associate Justice, members of the Supreme Court, Attorney Lorenzo Tañada from the Free Legal Assistance Group for Petitioner Lagman.
Good morning, Your Honors. I'm Attorney Elmer C. Barreda, and I'm respectfully entering my appearance as counsel for the petitioners in GR number 271059. Thank you very much, Your Honors.
Good morning, Your Honors. Jericho Salenga appearing as counsel for Aquilino Coco Pimentel III and Pantaleon Bebot Alvarez. Thank you, Your Honor.
Magandang umaga, Your Honors. I'm Attorney Joseph Lemuel Bakiran, respectfully appearing as counsel for FPJPM, Your Honors. Thank you.
Good morning, Your Honors. I'm Attorney Renelyn Arellano, appearing as counsel for Petitioner FPJPM. Thank you, Your Honor.
Chief Justice, Senior Associate Justice, and the Honorable Associate Justices of the Supreme Court, good morning. I am Attorney Vopetro Angie Peña, respectfully appearing for Representatives Edgar Erice and Laila de Lima in GR number E-04036.
Good morning, Your Honors. I am Attorney Bianca Isabel D. Soriano, also counsel for Petitioners Erice and de Lima. Thank you, Your Honors.
Appearance for respondents, please.
Good morning, Your Honors. Good morning, distinguished amici. The Office of Solicitor General respectfully re-enters its appearance for the respondents in these consolidated petitions. I am Solicitor General Darlene Marie B. Berberabe. With me today, Your Honors, are Assistant Solicitor General Marisa B. de la Cruz Galandines, ASG George Ortha II, ASG Jennifer Fanjalan Legaspi, ASG Samantha Kamitan, ASG Orlando Polinar, and ASG Mark Perete. Other lawyers of the OSG are in the gallery to provide assistance whenever necessary. Also with us, and pursuant to this Honorable Court's directive, our Department of Economy, Planning and Development, Undersecretary Joseph Capuno, the DepDev representative to the Investment Coordination Committee, and DBM Assistant Secretary Romeo Matthew Balangkit, the DBM's representative to the Development Budget Coordination Committee or DBCC. Other representatives from the DBM and from the DepDev, as well as from the Bureau of Treasury, are also in the gallery. Thank you.
Appearing as Amici Curie are Attorney Florencio Biabat, Professor of Praxis at Ateneo School of Government, Honorable Franklin M. Dillon, former President of the Senate of the Philippines, Honorable Benjamin Diokno, Member Monetary Board, Bangko Sentral ng Pilipinas, Honorable Jose Maria Clemente Joey S. Salceda, former Representative and Chair, Institute of Peace and Strategic Studies. I understand Honorable Dillon would like to say some manifestation. Please proceed.
Thank you, Mr. Chief Justice. Secretary Associate Justice Leonen, members of the Honorable Court, a pleasant good morning to all of you. First of all, allow me to express my appreciation for your invitation to once more appear as a friend of the court in this case. As we all know, on record, this case involves a question of first impression, the constitutionality of unprogrammed appropriation. Given the context of our political situation today, I am making this manifestation to urge the Honorable Court, subject to your better judgment, to decide this case as early as possible. As early as possible because the budget will be submitted to Congress 30 days from the State of the Nation address, which is the fourth Monday of July. And the budget will be submitted within 30 days after that, in accordance with our Constitution. We are making this manifestation to respectfully urge the court to decide on this case while as early as possible, preferably by Congress, because the decision of this court will provide guidance not only to the government but to the public in general as to these animal hold and program appropriation. We have witnessed for the past 2 weeks the political turmoil that has resulted from this issue. You know, senators have been charged and they will be held to answer for whatever acts they have committed in contravention of the law. But that is why it is very critical, Your Honor, that this Honorable Court provide Congress and the public in general as to the guidelines of what is constitutional and what can be done with the unprogrammed appropriation. We make this plea for the court not to wait until the end of the year, because there will be decisions made by Congress during that period, and it is best that Congress be given the guidance of this Honorable Court. Thank you very much, Chief Justice. Thank you very much for the time that we allotted to us.
Thank you, Mr. Senate President, for your manifestation. We note that. We also would like to let you know that the court is conscious of the timelines in the budget process. Thank you very much. We proceed with the interpellation of Justice Leahy Rosario.
Thank you very much, Justice Amy, for the kind accommodation. I have a few questions for the Solicitor General. May I request her to please approach the podium?
Good morning, Your Honor.
Good morning, Madam Solicitor General. How are you today?
As good as can be, Your Honor.
I hope you are in good spirits as the other members of this court, I suppose.
Yes, Your Honor.
Before I proceed, Madam Solicitor General, I cannot help but observe that your first name, Darlene, suits you perfectly. Because wherever you go, you seem to be the Darlene of the crowd. I hope the opposing counsel will not take offense at this light-hearted remark, because it is completely innocuous and certainly not indicative of any bias on my part. But I'm willing to voluntarily recuse myself from this case, if that is the price to pay for being honest.
Thank you, Your Honor, for making the atmosphere light. Thank you.
Now, I had previously decided to forego my turn to interpolate. Upon further reflection, however, I realized that it would be helpful for the Solicitor General to address some questions which may further clarify the issues before the court, particularly those concerning the scope of the discretion of the president, the breadth of the trigger, the breadth of the triggering conditions rather for unprogrammed appropriations, the constitutional fiscal ceilings, and the relationship between the BSP and the unprogrammed appropriations. Okay? In the interest of time and for the sake of expediency, I will simply read my prepared questions, if that is acceptable to the parties. Okay?
Most certainly, Your Honor.
Now, do you agree, Madam Solicitor General, that the unprogrammed appropriations, by their nature, conferred upon the President a degree of discretion not ordinarily present in programmed appropriations, since their implementation depends upon the subsequent occurrence of specified conditions? Sabay-sabay ko na even the follow-up questions. Anyway, the follow-up question will not depend on your answer, on how you respond to the main question. And would you agree that the breadth of the President's discretion to utilize UAs depends largely on the triggering conditions prescribed by Congress? For instance, under the 2006 GAA, the implementation of a UA-funded project may be authorized once collections from any one of the identified non-tax revenue sources exceed the target. Now, in your view, is that a sufficiently reasonable and limiting trigger? But if the trigger may be satisfied by an excess in just one revenue source, regardless of the performance of the other revenue sources, would that not significantly broaden the executive's discretion to implement UA-funded project? And this further follow-up question, would that not create the risk of expenditures being undertaken despite overall revenue shortfalls, contrary to the mandate of the constitutional objective of maintaining a budget ceiling and fiscal discipline? You may now respond, Madam Sergeant.
Thank you, Your Honor. On the point on the discretion of the executive in regard to the execution or the implementation of the unprogrammed appropriations. It is the position of the Republic that there is discretion, although this discretion is constitutionally lodged in the executive in the face of the budget, which is budget execution. Now, whatever discretion that the President has or that the Constitution has provided the President, it is bounded by the triggers that are statutorily provided, meaning each GAA would provide for the special provisions or would provide for the triggers. So this means that in a certain view, the unprogrammed appropriations are actually based on tight fiscal discipline because it requires that before the executive can fund the unprogrammed appropriations, there has to be a certification from the Bureau of Treasury that the trigger has been met and that there is excess funds. And that is why it is our position that there are specified limits to the power that is given to the President. Now, with regard to the breadth of the power to utilize the UAs depending on the trigger, so we have been also monitoring the triggers, and sometimes, at some point, there was a change in the wording of the trigger, which was after the decision by the court on the Araulio versus Aquino. And this is because, based on our briefings with the executive department, the triggers that are provided are not constitutional requirements, but they are statutory requirements. And that statutory trigger was the one that was being interpreted by the court in such case. And therefore, the executive responded by clarifying what are the triggers that the executive should observe. Now, with regard to the trigger on referring to any one trigger, your question was whether this is reasonable versus the aggregate, and versus referring to a trigger that will refer to the aggregate revenue. And it is the position of the Republic that since it is a statutorily provided trigger, then it is within the power of the purse, which is lodged in the Congress, in providing that any excess in any one of the non-tax revenues will trigger the funding of the unprogrammed appropriations. Now, with regard to the risks on whether the funding or the implementation of the unprogrammed appropriations will go beyond, for example, the ceiling, or will go beyond the deficit target that has been set by the executive, it is the position of the Republic that the unprogrammed appropriations is not deficit-inducing, and that generally it is deficit neutral. And why is this the case? This is the case because the unprogrammed appropriations will just be implemented if there is a certification as to the excess of any non-tax revenue or any new revenue, which, based on the BESF, if there has been an excess in any of the committed targets by the executive, then and only then will the unprogrammed appropriations be implemented. So, Your Honor, if I may finish my answer with regard to the difference between the programmed appropriations and unprogrammed appropriations. The programmed appropriations under the GAA, once they have been passed as a law, are already generally given an allotment order, which we call the GAAW, while on the other hand, the unprogrammed appropriations will have to go through a more strict process, which is there has to be an issuance of the SARO, and at the same time, there has to be a certification from the Bureau of Treasury as to the existence of the excess of the targets that have been committed by the executive. That's my answer, Your Honor.
I'll go to my next question.
Yes, Your Honor. Thank
Now
you.
I understand why you are always considered the darling of the crowd. Anyway, this is my next question. According to, or rather, Article 7, Section 22 of the Constitution requires the President to submit a BESF, which includes projected expenditures and the revenues expected to finance them. Now, can you point to this, to the court, to any specific revenue projection in the BESF that corresponds to the amount allocated for unprogrammed appropriations in the NEP or NEP?
Your Honor.
Did you understand the question?
My appreciation, Your Honor, is if there is an item, or if I can point to an item in the BESF that can be the basis for the funding of the unprogrammed appropriations.
Yes. Any specific revenue projection in the BESF?
Yes. Your Honor, the funding basis for the unprogrammed appropriations are also based on the revenues and sources of financing identified in the BESF. Only it refers to the excess. So if there are targets that have been committed or identified under the BESF, for example, if there is a non-tax revenue, and for example, the dividends, the commitment, for example, of the executive is 20 billion pesos for a year. If there is excess of collection on the dividends, then that excess, let's say 1 billion pesos, will be the funding for the unprogrammed appropriation. So, in other words, Your Honor, the relationship is if you look at the BESF as to the sources of financing, that will also be the reference, and if there is excess on the commitment by the executive, then that will be the trigger.
If there's no specific revenue projection in the BESF corresponding to the ceiling or the UA ceiling, would it be fair to say that the BESF does not identify any particular source of financing for the full amount of the UAs?
Your Honor, it is the position of the Republic that the prohibition to breach the ceiling refers to the programmed appropriations contained in the BESF, and that the unprogrammed appropriations are not part of the BESF simply because the funding of the unprogrammed appropriations are not sourced from the committed targets for the operations of the government. There is, may I call the attention of the Honorable Court to Article 7, Section 22. The President shall submit as the basis of the General Appropriations Bill a budget of expenditures and sources of financing. And this is the BESF that is submitted by the President. The unprogrammed appropriations are in the NEP but not in the BESF. Now, also under Article 6, Section 25, which it is the position of the Republic, should be interpreted vis-a-vis Article 7, Section 22. Section 25 under Article 6 says, the Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. And we were looking at this phrase, for the operation of the government as specified in the budget. Congressman Salceda, when he discussed the history of the budget laws from RA 922 in 1954, there was a previous budget law. I think in the 1930s, there's Presidential Decree 1177, and all of these budget laws, which contain the fiscal parameters, speak of a two-envelope framework. And the two-envelope framework referred to first the operations, the regular operations for the government, and second would be the new projects, much like or similar to the unprogrammed appropriations. And I say that because we were looking at Section 25 and why did it have to qualify the appropriations for the operation of the government. And so it is our position that it is the BESF and not the unprogrammed appropriations which are being referred to that cannot be breached with the constitutional requirement of the ceiling, Your Honor.
Okay. If unappropriated appropriations are not supported by any specifically identified revenue projection in the BESF, how can the court determine whether the constitutional requirement that expenditures be matched with sources of financing has been satisfied?
Your Honor, it is the position of the government that the constitutional requirement is that the sources of financing just be identifiable. And they are identifiable when we refer to the targets in the BESF, and the trigger would just pertain if there is excess in the collection, then that will be the trigger. Another trigger would also be the support to the foreign assisted projects. So it is our position, Your Honor, that the requirement is it should just be identifiable. And it is our position that we are able to identify the sources.
Now, is it also your position, Madam Solicitor General, that Congress may authorize expenditures through UAs even though the revenues intended to finance such expenditures are neither specifically projected nor specifically identified in the BESF?
Your Honor, it is our position that it isn't really specifically identified, and it is in the nature of the unprogrammed appropriations to not be in the BESF because these do not pertain to the appropriations for the operations of government, because unprogrammed appropriations inherently by its nature would pertain to projects or programs which are contingent on the existence of the fund. So meaning there is a policy determination by Congress that these UA projects, activities, or programs are not necessary for the operations of the government, and they are willing to forego if the triggers are not met.
Last question for the Soldier. Considering your position, Counsel, can you point to to a constitutional limitation, if any, that prevents Congress from significantly increasing the amount of UAs beyond the revenues identified in the BESF?
It is the position of the Republic, Your Honor, that there is no constitutional requirement. That's why it is our position that in the case of Belgica versus Ochoa, when the Supreme Court already said that the UAs are constitutional, we respectfully submit that that should be upheld, and we are aware of the disappointment, frustration of the people with regard to the unprogrammed appropriations or how they have been spent, but we also believe that the Constitution itself provides for the mechanisms to correct the otherwise unwise policy decisions that have been made, which is the electoral process, the ombudsman, audits by the COA, which are all constitutionally provided, Your Honor.
Thank you very much, Madam Soljan. In
Thank
the
you very much,
interest
Your
of
Honor.
fairness and balanced process, may I likewise request the counsel for the petitioners to take the podium for interpellation. Maybe we can start. May I request the counsel for petitioner Lagman? Sino ba abogado?
Good morning. Please submit, Your Honor.
Counsel, your petition does not clearly allege petitioner's standing. I understand Representative Lagman, may he rest in peace, was a member of the House. Could you please clarify the specific basis for petitioner's standing before this court? Does every legislator who disagrees with the contents of an Appropriation Act automatically acquire standing to challenge it before the court?
Your Honor, as a member of the House, Representative Lagman has standing to question if he believes that provisions of the Constitution have been violated. And this is part of the interpellation that Representative Lagman had with Representative Joey Salceda, where he questioned the issue with regard to unprogrammed appropriations. So it is of this humble representation that Representative Lagman, feeling that he had no other recourse but to raise the matter to the Supreme Court.
If may I add, Your Honors.
Go ahead.
Your Honors, as duly elected representative of their respective congressional districts, the petitioners, especially the late Congressman Edsel Lagman, Your Honor, is also an aggrieved party together with the sovereign people they represent by the subject and constitutional act of the Congress of the Philippines, Your Honor. And moreover, in Padilla versus Congress, Your Honor, versus Congress of the Philippines, in GR number 231671, Your Honors, and in Tanyana versus Congress of the Philippines, in GR number 231694, and Lagman versus Ochoa Jr., in GR number 193036. The Supreme Court, Your Honor, ruled that the legislators are proper petitioners in cases like the instant petition, Your Honor. And the ruling in Padilla and Tanyada explains that the court has recognized that every citizen has the right, if not the duty, to interfere and see the public offense may be properly pursued and punished, and that a public grievance be remedied. When a citizen exercises this public right and challenges a supposedly illegal or unconstitutional executive or legislative action, he represents the public at large, thus clothing him with the requisite locus standi, Your Honors, please. Yes, Your Honor.
You filed a petition under Rule 65. Yet, the bicameral conference committee is not exercising judicial or quasi-judicial functions. When you say grave abuse of discretion amounting to lack or excess of jurisdiction, which specific jurisdictional boundary was crossed?
The power of the legislature, Your Honor, I feel, Your Honor, that when Congress, both the House and the Senate, approved on third reading the respective versions of the bill, the bicameral conference committee has the duty to only reconcile differences between the version of the House and the version of the Senate. And since there was no differences between the two versions, the act of the bicameral conference committee in replacing the wisdom of the House and that of the Senate constitute grave abuse of discretion.
Is it your theory that the bicameral conference committee acts ultra vires whenever it introduces matters not found in either chamber's third reading version?
It is the position of this representation
Okay.
that
But Counsel, in Tolentino, in the case of Tolentino versus Secretary of Finance, if you're familiar with the ruling of the court in that case, the case ruled, or the Supreme Court held, that a bicameral conference committee has the authority to include in its report an entirely new provision not found in either the House or the Senate bill. If I may be allowed to read, maiksi lang naman to. Indeed, this court recently held that it is within the power of a conference committee to include in its report an entirely new provision that is not found in either the House bill or in the Senate bill. If the committee can propose an amendment consisting of one or two provisions, there is no reason why it cannot propose several provisions collectively considered as an amendment in the nature of a substitute, so long as such amendment is germane to the subject of the bills before the committee. After all, its report was not final, but needed the approval of both houses of Congress to become valid as an act of the legislative department. The charge that in this case the conference committee acted as a third legislative chamber or chamber is thus without any basis. Following Tolentino, Counsel, is it correct to say that the bicameral conference committee did not exceed its constitutional authority by introducing provisions not present in either the House or Senate versions?
it is the position, this is humble representation, that it has to be revisited, the decision of the Tolentino case. Maybe one question, I'm not familiar if it also dealt with budget, because if it is just a few items with regard to an proposal coming from the bicameral conference committee, then as agreed, it can go back and be reviewed by the respective chamber. But in the experience of budget legislation and the bicameral conference committee, and as mentioned by Amici, former Senate President Franklin Drilon, the budget that is distributed for ratification to the members of the House is almost 6 to 8 inches thick. And when it is given back to the respective chambers, I don't think they are able to go over one by one each and every changes that were made in the programmed and unprogrammed appropriations. So if we are looking for guardrails, I think it is important to distinguish between ordinary legislation with regard to the Tolentino case and budget submission, which would call for ratification of a totally different, pardon the word, animal compared to what the Senate and the House initially discussed and approved on third reading.
If I may add, Your Honor, please.
Go ahead.
Your Honor, the Tolentino case, Your Honor, must be read in conjunction with the Article 6, Section 25, subparagraph 1, Your Honor. Even though, Your Honor, the Tolentino case stated that the bicameral conference committee, Your Honor, may insert new provisions as to the Senate House and the lower house version, Your Honor. However, the BICAM still needs to respect the constitutional limitation imposed under the 1987 Constitution, Your Honor.
That's my last question. Thank you very much, Counsel.
Thank you very much, Your Honor.
Now it is the turn of the Counsel for Pimentel to please respond to my questions or other question. Counsel, you argue that the 2024 GAA is void because it did not pass 3 readings on separate days, and that the President's certification of urgency was invalid because there was no public calamity or emergency, right?
Yes, Your Honor.
Okay. However, in Calleja versus Executive Secretary, citing Tolentino, this court held that the factual basis of a presidential certification of urgency should be reviewed differently than martial law or emergency powers because basic individual rights are not at stake. Moreover, Abasquida held that judicial deference is warranted out of respect for co-equal branches. Given these cases that I cited, what standard would justify this court to override the deference and to substitute its own factual judgment for that of the President's?
Your Honor, in our petition, Your Honor, we stated the definition of calamity as a legislative enactment, Your Honor, present in Republic Act number 10-121, Your Honor, the Philippine Disaster Risk Reduction and Management Act, Your Honor. So based on that definition, Your Honor, the meaning of calamity is not complied, Your Honor. Respectfully, Your Honor, we would like to have that meaning, Your Honor, as legislated, be applied in this case to declare such declaration or summation of calamity as invalid, to give the perceived time or absence of it in the enactment of this General Appropriations Act, Your Honor.
Okay. Thank you, Attorney. I'm about to conclude my interpellation. Can I just request the counsel for Congressman Erice to please take the podium as well? Isang tanong lang po, Attorney. Counsel, Article 6, Section 25, Paragraph 4 of the Constitution requires a special appropriations bill to be supported by funds actually available or by a corresponding revenue proposal. Agree?
Yes, Your Honor.
But these requirements apply specifically for special appropriations bills. There are no similar textual requirements for general appropriation bills. Tama?
We humbly submit, Your Honor, that the specific requirement...
Tapusin ko na yung tanong ko.
Yes,
So
Your
what
Honor.
is your textual basis for claiming that unprogrammed appropriations are unconstitutional because they are not supported by funds actually available? Go ahead.
If I may, Your Honor, our submission is that the requirement is not for the funds to be actually available, but for the sources of financing to be included in the BESF, Your Honor, such that all items of appropriation, whether programmed or unprogrammed, will fulfill that requirement, Your Honor. Doesn't have to be that there is an actual source already.
Same with the early manifestation, Your Honor. And just to add, Your Honor, as mentioned by one of the Amici Curie Secretary, former Secretary Florencia B. Abad during the oral arguments last April 7, Your Honor, the Constitution already provides the existing mechanism of special appropriations under Section 25, Paragraph 4, Article 6, which addresses the need for flexibility without sacrificing accountability, Your Honor.
Thank you. Huli na lang yung counsel. Meron bang FPJPM?
Thank you, Your Honor.
Thank you, Your Honor.
Attorney, your petition alleges that the Bicameral Committee Conference Committee unconstitutionally increased the special accounts in the General Fund in the 2025 GAA. Since SAGFs are created and governed by separate substantive laws, which of these laws already automatically appropriate the earmarked revenues as collected, and which of these laws still require further annual legislative action for appropriation by Congress? And this is my follow-up question. If the authority to spend already exists in previous legislation for certain SAGFs, how can Congress be said to have increased the appropriations recommended by the President when no fresh recommendation from the President is needed in the first place?
To answer the first question, Your Honor, there are two classifications of earmark revenues, Your Honor, the use of income in the general fund and the special account in the general fund. However, Your Honor, it is as you have said, Your Honor, the 13 laws already specified that the income from the 30 special penal laws that we mentioned in our petition, Your Honor, that the income that should have been included in the BESF, Your Honor, should not have been increased by Congress because of the specific provision of Section 25(1), Your Honor. While the Constitution provides that all appropriations should not, recommended by the President should not have been increased, the Congress should not have therefore increased the appropriations recommended by the President, Your Honor.
Attorney, ano po, sasagot ka rin ba?
We have the same...
We're done. O, sige. Thank you very much. Thank you, Chief Justice. I am done with my interpellation.
Thank you, Justice Rosario. May I call on Justice Ami Lazaro Javier to proceed with her interpellation?
Thank you very much, Chief Justice. May the Solicitor General graciously respond to my questions. Thank you. Good morning, Chief.
Good morning, Your Honor.
Madam Solicitor General. Okay. Madam Solicitor General, from your opening statement and all through your responses to the relevant questions of the court so far, you have consistently invoked the wisdom of Congress in the enactment of the budget, which, according to you, is a political question, hence beyond the reach of judicial review. Is that correct?
Yes, Your Honor.
Yes, thank you very much. So what do you mean by the wisdom of Congress in the enactment of the budget?
Your Honor, the position of the Republic is that although we recognize the expanded judicial power of the Supreme Court, which is different from the U.S. Legal framework, because in our Constitution, we have explicitly expanded the judicial power, and that we recognize that there could also be a review if there has been grave abuse of discretion. It is our position that we will still have to look at the Constitution if there are textually demonstrable standards by which an act of a co-equal branch should be evaluated. Otherwise, we believe that the Supreme Court also, in many of its decisions, have given much respect and deference to co-equal branches when the power has been constitutionally provided to that co-equal branch, such that the power of the purse being given to the Congress will then have to be delimited also only by what has been constitutionally provided.
Very well, Madam Solicitor General. So it is your position that the invocation of wisdom standing alone is not a magic wand that compels the court to desist from reviewing a case where constitutional issues are involved.
Your Honor, that the position of the Republic is that we would support that statement.
Yes. So wisdom is the ability to use one's accumulated knowledge, experience, and deep understanding to make sound judgments, good decisions, and act appropriately. can you cite specific cases where the court deferred to the wisdom of Congress in the enactment of the GAA? And for what reason, and for that reason alone, desisted from reviewing questioned items in the GAA, even though the constitutionality of these items was challenged before the court?
Your Honor, may I confer with my team just to be able to identify
Yes,
a
please.
specific case? Thank you, Your Honor.
Thank you. Oo.
Your Honor, with regard to the specific issue of GAA, we don't have a specific case now. We are able to, I'm able to remember like Tañada versus Angara, where there were pronouncements by the court that if there is unconstitutionality, if there is an allegation of unconstitutionality with regard to an act of a co-equal branch, the Supreme Court will give much respect and deference. I would also be reminded of the standard of proof that was enunciated by Justice Zalameda in the municipality of San Mateo versus Smart Communications, where Justice Zalameda said that if there is an allegation of unconstitutionality, the standard of proof is that the petitioners should prove beyond reasonable doubt. And it is a corollary principle to the presumption of constitutionality by a co-equal branch. And Your Honor, with your indulgence, if we may be allowed to submit a case to research on a specific GAA case to answer your question.
Please do that, Madam Solicitor General.
Thank
in
you,
the
Your Honor.
cases that you cited, did the court defer to the wisdom of the executive in sustaining the validity or constitutionality of a specific law? Or is it because the petitioners failed to master the quantum of evidence required?
In the municipality of San Mateo, Your Honor, it's the second one that the petitioners failed, and which is also our position in this case, that the petitioners have not alleged or have not discharged the burden of proof that is imposed upon them.
Yes, that's true. If we examine the cases of the Supreme Court, deferring to the wisdom of the political departments of the government, it is only because the invocation of wisdom, or the principle that we must respect the wisdom of the political departments, is just an aside. It's just an additional ground. And it's never cited as the lone ground in sustaining the constitutionality of a questioned law or issuance. Do you agree?
Your Honor, I would agree that since the 1987 Constitution, the political question, in fact, has been really set aside because of the expanded judicial power. Your Honor, in my notes, because I also am remembering a case which is Tañada versus Angara, but this is not a GAA case. This was about the WTO, but when I read it, I noted it down as a note for the Supreme Court not reviewing the wisdom. This is by Chief Justice Panganiban, and there were excerpts where the Supreme Court said that the responses to the questions on whether entering the WTO would bring more prosperity, employment, purchasing power, that they involve judgment call by our policymakers for which they are answerable to our people during appropriate electoral exercises. And if I may, Your Honor, it went on to say, again, referring to the burden of proof, it said that we find no patent and gross arbitrariness or despotism by reason of passion or personal hostility in such exercise, which we believe, Your Honor, is the standard for grave abuse of discretion. So I agree, Your Honor, political question, we won't stop at the issue of whether it is a political question because the Supreme Court would have the power to determine if there has been grave abuse of discretion. And it is just our submission that then the Constitution we will still look at the Constitution if it has provided for the parameters by which the Honorable Court will have to evaluate. Otherwise, if there are no textually demonstrable standards, then that means that in certain powers which have been lodged constitutionally by the constitutionally to the other co-equal branches, then the judiciary will be given a special position to supplant its policy or wisdom on powers that were given constitutionally to the other branches.
Madam Solicitor General, the court doesn't supplant. The court nullifies or sets aside, but never supplants its wisdom over the wisdom of the political departments. That is not the role of the judiciary.
I submit, Your Honor, I say it without intention to put in a negative light. I might have misappreciated, Your Honor.
It's all right,
We submit, Your Honor.
Madam Soljan. That's well taken. So, I'd like to stress that the case that you mentioned, Municipality of San Mateo versus Smart, is a division case. First division, where Justice Alameda sits as a member, as a senior member at that. So, are you still invoking it?
Your Honor, I have in my notes also, because the Municipality of San Mateo is just one. If I may go to my notes, Your Honor, to be able to share the other cases.
Actually, you may invoke it because the Chief Justice also sits as chair in that
It's a
division.
decision, so it's okay.
Yes.
Because the division is part of the Supreme Court
Yes,
itself.
of the law of the land.
Thank you, Your Honor.
Thank you. All right. So, on the other side of the fence, can you please cite specific cases where the court nullified specific items in the GAA for being unconstitutional, notwithstanding the government's invocation of wisdom on the part of its political departments, such as the executive and the legislature?
Your Honor, I think it's the Belgica versus Ochoa, where was it the Countryside Development Fund? Alin ba yung CDF? Alin yung PDAF? The Belgica, in the Belgica case, the Supreme Court nullified the PDAF for its undue delegation to the legislature. It's a post-enactment intervention by the legislature in choosing which are the programs to be funded, and there was also a provision of a certain amount to legislators after the legislation, which stage is given to the executive, but the legislature was in fact given the power to interfere.
Yes, very well, Madam Solicitor General. I was hoping you would mention the PhilHealth, where you did not file a motion for reconsideration. And the Filipino people thank you for that.
And of course, I thank also the Supreme Court for the wisdom in that case, Your
Yes.
Honor. Thank you.
And we did not supplant the wisdom of the executive and
Yes,
the
Your Honor.
legislature. Okay. In the DBM's website, unprogrammed appropriations are defined as those which provide standby authority to incur additional agency obligations for priority programs or projects when revenue collection exceeds targets and when additional grants or foreign funds are generated. What do you mean by standby fund? From your understanding.
Standby appropriations, Your Honor, mean that the triggers are identified, and if and when the trigger is met, therefore, the programs, activities, and projects will then can then be funded. So it is contingent on the realization or on the existence of the triggers.
Yes, so it is ready or held in reserve, correct?
No, Your
Held in reserve. That is how the dictionary defines it. It is ready for use. Is that correct? Or we don't agree with the dictionary's definition?
No, Your Honor, because there is yet no fund, and it is dependent on the meeting of the targets and if there will be an excess in the target.
Yes, so there is reservation but no funds. Correct? Yes, even though we have not collected yet, we're reserving the funds already.
Yes, so to speak, Your Honor. So
Yes.
if it will happen, then that fund will can be used for the unprogrammed appropriations.
So if it doesn't happen, there will be no standby funds.
Yes, Your Honor.
Yes. All right. So does standby funds necessarily connote an emergency which is not covered by the programmed appropriations?
Your Honor, if I may clarify, I don't remember that we defined or we used the term standby fund.
No,
but it's,
only DBM does. Only DBM does in its website. So you're debunking the definition of DBM?
well, Your Honor, I remember in our briefings that we were discussing standby appropriations. I remember them sharing with me the definition of a standby appropriation, but not a standby fund. If I may be corrected, Your Honor, we have the representative from the DBM, if it would be okay with you if I
Yes,
could
please.
clarify and be
Yes.
corrected also?
Okay, what is meant by standby fund? Do we have a special definition that is contrary to the ordinary meaning of standby funds?
Your Honor, so also my team confirms that our understanding is there's no reserve fund, but it is
There is no reserve
there's
fund.
no reserve fund.
But only earmarked.
Okay, the reason why I hesitated and paused, Your Honor, is that when earmark, it is my understanding that there should be real funds that are there, but in this case, it is conditional. There is no
Correct.
fund yet.
Conditional reserve. You can say that it's a conditional reserve. So if it is generated, so be it. If there is no generated fund, there is no reserve. Reserve is just an abstract, right?
Yes, Your Honor. I would agree with your explanation, Your Honor.
All right. So it's, ma'am, yes. Yes, please.
Magandang umaga po.
Magandang umaga sa'yo.
I am Andrea Magtalas po from the DBM.
Opo.
For clarification po, the DBM defines unprogrammed appropriations that as they provide standby authority for the agencies to incur additional agency obligations for priority programs and projects.
Yes.
So we confirm that definition, but we clarify humbly that it would be the authority, the authorization of the legislature, and the appropriation that is on standby, and the funds are merely earmarked.
So, standby does not mean to be incurred. There must be an emergency. There must be an urgency. That is the meaning of standby. As far as DBM is concerned?
As far as DBM is concerned, the authority granted by the legislative through the unprogrammed appropriations is a standby appropriation, which allows us, if triggers are met, the existence of the triggers are certified, to release the allotment necessary for the agencies.
So we're not speaking of any urgency. We're not speaking of any emergency when we provide unprogrammed appropriation.
The unprogrammed appropriations as legislated would be dependent on the priority programs and projects not covered by the programmed appropriations and are deemed necessary, such as foreign assisted projects that do not yet have final loan agreements, which could happen during the fiscal year.
All right. So on one hand, we have deficit, budget deficit. Is the funding of the deficit certain? Or it also depends on whether we could generate the funds to cover the budget deficit?
When the DBM submits, when the executive submits through the DBM, the BESF, Budget of Expenditure and Sources of Financing, there is an anticipated level of deficit. We are working on a deficit.
Yes, correct.
budget.
So anticipated deficit. And do you have anticipated sources for this deficit?
Yes.
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 Pretty much like unprogrammed appropriation. Unprogrammed appropriation is another form of deficit. Correct? Because there are no existing funds. But we are providing the programs and projects because we anticipate funding. Correct? Yes?
Your Honor, may I be allowed to
Yes,
answer?
please, Solicitor General.
It is our position that the unprogrammed appropriations are not deficit-inducing. In fact, they are generally neutral because the sources of funds are identifiable, contingent. If there is excess,
Yes.
then the source of fund will be ready, and therefore it should not produce a deficit because the source of fund is identified.
Yes. So, I don't disagree with that. I fully agree. And I would like to emphasize again that the contingency funds that will cover the deficit on one hand, all right, is the status of the deficit to be covered by funds that the government may or may not be able to raise is similar to the nature of the funds that we will raise still in the future to cover unprogrammed appropriations. That is the similarity that I would like to emphasize. And see, they're both non-existent when the unprogrammed, when the GAA was enacted. Do you agree?
Your Honor, if I may, with regard to the deficit target, it is our understanding, and please correct me, ASEC Angel, that even that the target is planned, discussed, deliberated on. Okay, so meaning the BESF will include all the sources of financing, and the financing could be local borrowings or foreign borrowings, and the DBCC, and in their discussions, there is in fact a target that they wish to be within and not reach.
Yes.
And all of those, based on the BESF, will be observed in the operations of the government. And that's why it is our position that since it has been planned as well, it's usually a range. I think it's a 5% to 7% deficit target, which is a big amount. And therefore, even the borrowings go already into the equation of meeting that deficit target. Now, in regard to the unprogrammed appropriations, if I may make a delineation, a respectful delineation of excess and surplus, because what the UAs are based on would be an excess in the collection of the revenue target and not surplus, which surplus they have been trying to explain to us this technical term. Surplus would refer to the definition of revenue. You spend more than you earn.
Yes.
You earn more than you
All
spend.
right.
That is a surplus. So the expenditure is in the equation of a
Yes.
surplus, while in the excess, it just pertains to the excess in the collection.
Yes, that's very well explained, Madam Solicitor General. But it doesn't deviate from my point that the funds intended to cover the deficit are still uncertain whether they may actually be raised on one hand. On the other, the UAs. The UAs also have no funding, but we have triggers. And whether we will be able to achieve funding from these triggers, or whether the triggers themselves may even occur, is uncertain. That is my point, the uncertainty of both funding for the deficit and funding for the UAs. All right, I will go to my other point. Yes, you are excused, ma'am. Thank you. So, we cannot liken from your definition of standby funds. Standby funds is not for emergency, it's not for any urgent projects of the government. Okay. But do you say that the programmed appropriation, the projects or programs under this category are urgent and matters of emergency?
Your Honor, the unprogrammed appropriations, the PAPs, projects, activities, programs, are not, I would not describe them as emergency, because the programmed appropriations would have the contingent fund. Meron bang emergency fund? Emergency funds, a programmed appropriation? Or there's the calamity fund and the contingent fund, which are all in the programmed. The unprogrammed appropriations are also PAPs that are deemed important by the executive and the legislature, but because of the limited fiscal space, they are, I think, forced to put them in the unprogrammed appropriations and wait for excess in the collection of their committed
All right.
revenues.
So, there are no urgent projects under the programmed appropriation.
Your Honor, there could be, but it is not the essential characteristic of the unprogrammed appropriations, because, for example, the foreign assisted projects, from the executive point of view, will then be urgent. There is a timing dimension to it. I think that if the executive does not foresee it being approved right away, then it goes to the UA and not the programmed appropriation because of the timing.
All right. So, there are also urgent and emergency projects under the UAs.
There could be, Your Honor, like the
Yes.
FAPs.
Okay, so it's not correct to say that the UAs cover non-emergency or non-urgent projects.
Yes, Your Honor, I would not describe it as a common descriptor to all,
Yes.
but they are important to the executive.
Important but not urgent, not emergency.
Not emergency.
Okay,
Your Honor.
while the programmed projects are a mix of urgent and non-urgent.
The programmed appropriations, we could say that, Your Honor.
Yes. All right. So actually they can overlap, right? Yes.
Yes, Your Honor.
Yes. So they can be moved from unprogrammed, though it is urgent, it can be moved to unprogrammed. And unprogrammed can be moved to programmed.
Yes, Your Honor. I think that was also what happened. And how it was explained to us is that, again, in reference to the two-envelope framework that the executive has has been guided through the years that the funding for the appropriations that are meant for the operations of the government would be the programmed, and those that the legislature can live with without those programs because it is contingent on the happening of the triggers, then
Are moved to unprogrammed.
would go to unprogrammed,
Yes.
Your
So,
Honor.
in terms of hierarchy of value, all right, the programmed priorities, programmed appropriation is on top.
Yes, Your Honor, that is correct. And in fact, also the effect is that after being included in the GAA, it already automatically, as a general rule, will have a GAAW, the allotment order. While the UAs, you will have to go through the SARO approval and a certification from the Bureau of Treasury that there is the existence of the excess
Yes.
funds.
So the standby fund may or may not be realized.
Yes, Your Honor.
Yes. So we cannot. Can you liken the standby fund to a generator, which switches on automatically or manually once there is brownout?
There is the comparison, Your Honor, in the sense that if there's a trigger, an event that will trigger its happening,
The trigger
then
is the
it's correct.
brownout
Yes, Your Honor.
and the availability of the generator.
Yes, Your Honor.
Yes. So in that sense, is it a standby generator?
Yes, Your Honor,
Yes.
it's a generator.
To provide current or light where the regular supply runs out. Correct?
Your Honor, that last description, it's actually exceeding the collection. So it doesn't run out, but the executive has exceeded its targets.
Even though in the meantime, the budget deficit has not been fully covered.
Your Honor, it's the point that we hope to clarify. So again, and maybe if okay with you to ask for the expertise of our budget secretaries, because it is our understanding that the deficit is actually, there is a lot of intention to it and deliberateness as to what will be the source, how much will be borrowed, and that's already, they have a formula and they have an equation for it.
It's all right. I will go to my next question. So, you speak of priority programs or projects. Okay. Can you cite examples of priority programs or projects that were included in the unprogrammed appropriations of 2024, 2025, and 2026?
Wala. Your Honor, may I ask for a list of the unprogrammed
Yes,
appropriations?
please. TOR 25, 26.
Your Honor, if I may request for the DBM representative to share the UA items.
All right. Yes, please. It's all right. Can you just submit to us the list of these priority programs? Are they listed as priority programs, or who categorized them as priority programs?
Your Honor, what we have here would be the list of UA purposes covered from 2016 to 2026. And one example of a priority program and project that is in the UA would be the revised AFP modernization program.
Unprogrammed. All right, but isn't AFP modernization program a long-term program?
Yes.
Yes. Of how many years?
There are phases, but I think more than 10 years.
Yes,
I will
so
validate.
they're quite predictable, right? They're recurring in every GAA I could ever remember.
There is a portion of the revised AFP modernization program that is part of the programmed appropriations, but to provide possible additional cover for the program, there's also an amount included in the 2024 and 2025, among others.
Because they are
unprogrammed
funded in phases, correct?
Yes,
so,
Your Honor.
for every GAA year, this item is anticipated, correct? It's not emergency, it's not urgent. It is a recurring program of the government, which obviously assumes a priority, a priority or urgent consideration by the executive and the legislature. So why did you move it to unprogrammed when it is so programmed?
Honor, may I
Yes.
answer your question? Based on the clarification of ASEC Angel, the AFP modernization out of the recognition that it is an important program is also in the programmed appropriation, and a certain amount is also in the unprogrammed, just in case it will be added to. Now, I don't think, because of the fiscal space that limits the executive with regard to the programmed appropriations.
So what cannot be done directly insofar as the programmed appropriations are concerned can be done indirectly under the unprogrammed appropriations, which give a lot of fiscal space.
Your Honor, the unprogrammed appropriations, again, because the sources of funds are not for sure to happen, and that's why we likened it to like a list of programs that are important to the government, but they can in fact live with dispensing with them if the sources of funding will not happen.
When you retain it under program funds, and because of its inclusion, a deficit is incurred by the government. Okay. Funding will be uncertain as well. But nevertheless, we have certain sources to cover these funds. Okay. So why do we have to move it to unprogrammed funds when the funds are also uncertain?
Your Honor, since, in fact, even before the 1987 Constitution, so our executive has always included in their in the NEP the unprogrammed appropriations, and I think based on the presentation of our amici that it provided some kind of flexibility to our executive department, and the reason why I add that is since budget is since the power of the purse has been lodged in the Congress, and the planning and the execution are lodged in the executive, the targets or objectives of how they can perform with limited fiscal space would be given a lot of deference as well, because of their many years of doing their job of the planning, legislation, and the execution of the budget, which is the contemporaneous construction of their power under the Constitution.
I agree, but only if it is untainted with grave abuse of discretion, not if it breeds corruption or bad governance.
Yes, Your Honor, it is our humble submission that, in fact, the vulnerability to corruption is not unique to the unprogrammed appropriations. It could also happen in programmed appropriations.
Correct, but it is enhanced. It is enhanced. All right. So, you maintain that there were certain criteria used by the legislature in shifting certain items from programmed to unprogrammed appropriation. Okay? And accord correct? Yes?
Yes, Your Honor, although I do not have the information, because we thought that
in general, correct? Yes,
Your
it
Honor.
goes to the wisdom, but it is also the duty of the government to lead us to the wisdom that led to this decision, because that is a big consideration for the court to resolve this case in accordance with the Constitution. So, as I said before, the invocation of wisdom is not its own excuse for being. It is not a magic wand that once it is flushed, the court will automatically desist from reviewing the issues at hand. All right. So it is
Correct.
but fair for the Filipino people to be apprised of how this wisdom is exercised and how it came about. Okay, for example, the share of local government units in the collection of special privilege tax was categorized under programmed appropriations in the 2016 and 2017 GAAs. But under the 2024 and 2025 GAAs, it was shifted to the category of unprogrammed appropriations. What standards were used by Congress for doing so?
Would you like to?
For the prior year LGU shares, Your Honor, in 2024 and 2025, the amounts were included in the unprogrammed appropriations because there is a need to certify the availability of such amount and that such amount certified be reconciled with the Bureau of Internal Revenue. So without such reconciliation...
That is the reason? You just want to reconcile the figures?
At the time of the preparation of the NEP,
Yes.
the reconciliation has not yet been
Correct,
completed.
but it's just reconciliation. It's a mathematical computation. That is the wisdom. Because you have yet to compute or you have to make the numbers
Without such
tally.
Without such reconciliation, Madam Chair, the executive placed the
Can we not
amount
have a
in the
more
unprogrammed.
substantive reason? I always believe that wisdom bears substantive reason, not mathematical reason alone. All right, let me go to the AFP modernization. Okay, under the NEP for the 2024 GAA, the President proposed the whole amount of 50 billion for this item, but Congress split this amount by assigning 40 billion under programmed appropriations and 10 billion under unprogrammed appropriations. Madam Solicitor General, please lead us to the wisdom underlying the splitting of this item under two different categories of appropriation.
Your Honor, I do not have the reason of Congress in splitting it, Your Honor. It is our understanding that when we refer to the wisdom, we do not mean that the conclusion can be considered as wise or can be considered as correct or can be considered as sound, but when we say that that the judiciary differs to the wisdom of a co-equal branch, then whatever considerations becomes an issue that will be dependent on their standards. And so that's why even if we all agree that certain choices have been unsound, it's our position that it is not the issue that we are trying to give an answer to.
It's always an issue, wisdom. That's why we say untainted with grave abuse of discretion. When wisdom is invoked by word alone, by lip service, but the substantial part of it is unwise, then it is not wisdom. All right. So you invoke, Madam okay, your excuse. Thank you. Solicitor General, the earmarking of different sources for programmed on one hand and unprogrammed on the other. Okay. To justify, all right, the unlimited amount that may be assigned under unprogrammed appropriation. Don't you think this is a superficial distinction, without which programmed and unprogrammed appropriations are one and the same, bearing the same features, except that programmed appropriations are made subject to constitutional limitations pertaining to the ceiling amount, while unprogrammed appropriations are made exempt from these limitations. It means while programmed appropriations have a ceiling, both visible and quantifiable. In contrast, for unprogrammed appropriations, sky is the limit.
Your Honor, I would refer to the history of the budget law, and which I think is the basis also of how our wordings in the Constitution has been this way. It appears, and it is curious also to us when we were looking at the beginning of the unprogrammed appropriation. At first, we thought that it just started in the 1989 GAA, but it appears that it predated the 1987 Constitution. So it goes into the fiscal policy of the executive. It goes into the fiscal space that they are trying to be disciplined about. And because of the responsibility of Congress to identify if ever there will be additional funds to already have the ready appropriation, that is to our understanding why the unprogrammed appropriations have become to be an integral part.
Illimitable.
All we are saying, Your Honor, because the issue in this case is whether the unprogrammed appropriations is unconstitutional, and it is our position that it is not unconstitutional, and that there is no there's no text in the Constitution or no text in the Constitution that defines or limits the unprogrammed appropriation.
Correct. That's why that classification was provided. Apparently to skip this prohibition. At any rate, for me, it is a paradox. Unprogrammed appropriations are fixed, hence they have a ceiling. It is like purchasing from the department store. No haggling. The prices are fixed. On the other hand, unprogrammed appropriations have no fixed ceiling price. Pretty much like a tiangge. Haggling is the name of the game. Pwede tumawad. Okay. Now, my position is the artificial distinction between programmed and unprogrammed appropriations. For me, it has a lot to do with our budget deficit. Okay, so may I ask again the good representative of the DBM to please respond to this question. In 2024, how much was our budget deficit?
Your Honor, the DBM ASEC Angel is requesting if we could ask the representative of the DBCC.
What is DBCC? It's like a radio station.
The Development Budget Coordinating
All
Committee.
right. Yes,
Your
yes,
Honor.
please come. Thank you.
Good morning, Your Honors.
Yes.
My name is
Good morning.
Romy Balangkit from the DBM, and I'm the chair of the DBCC Executive Technical Board. DBCC stands for Development Budget Coordination Committee, wherein its members are the economic managers, Your Honor.
Yes.
And they're responsible for targeting the deficit program over the medium term.
Yes. So my question was, how much was our budget deficit? in 2024?
Around 1.5 trillion.
Yes.
Madam
So,
Chair.
was the government able to cover this entirely?
Yes, but we even exceeded our deficit to GDP target of something like 5.6, and we breached it to 5.7, unfortunately.
So, we had extra money?
Yes.
Yes. Where did you use the extra funds that we generated?
Okay, so...
So we had a deficit and we were able to cover the deficit within the fiscal year
Yes.
in 2024.
Yes,
Yes.
that's correct, ma'am. Because...
So where did we source the funding for the deficit?
Okay, so the Treasury, when it borrows money, either from inside or outside, it would be using money for deficit financing and also for paying the principal amount.
All right, so nangungutang tayo
Nangungutang tayo, ma'am,
para may
punuan
pambayad tayo
sa hindi
sa
kayang
ating,
mapunan
sa hindi
ng
natin
BIR.
kayang
I-collect,
punuan.
yes.
So,
At saka-
gumagastos tayo ng sobra-sobra sa ating kita.
Yes, nangyayari po yun.
Yes,
Nangyayari
oo.
po
Lagi
yun.
bang nangyayari yun?
Last year, we breached also the deficit.
We breached because we
deficit-
borrowed.
We borrowed, yes.
Yes.
Deficit and borrowing.
Magkanong inutang natin? Kung di tayo imutang, meron pa rin tayong deficit.
Lagi po tayong may deficit.
Lagi tayong may utang.
Hanggang 2030, ang target po ng DBCC ay may deficit pa rin, but ang kailangan mangyari is yung deficit GDP ratio should be a downward trajectory. Kasi habang meron tayong deficit, tumataas pa rin yung accumulated debt natin. But it should
Natural.
it should not actually worry us if the expenses that we are using for the borrowings that we are getting from abroad or from domestic would be used for increasing the size of the economy. So maganda pong tingnan, Your Honor, na yung debt over GDP, dapat bumabagsak din po yan, pababa ng pababa, over the medium term. So, meaning, nothing to worry if the accumulated deficit or debt is increasing for as long as the size of the economy is also increasing.
Nothing to worry.
That's the position of the economic managers because we've been running
Nothing to worry.
at a deficit.
Kahit na mag-deficit, kahit na malubog tayo sa utang, okay lang. Basta nag-grow yung economy natin.
At nakakapagbayad po tayo, ma'am.
Nakakapagbayad tayo ng principal and interest.
Correct po, ma'am.
Okay. So, yung mga utang na yan, kailangan iutang kasi hindi natin ginagamit yung sources for the unprogrammed appropriations. Diba? Kung walang divide, kung hindi natin nilagyan ng category, o ito para to sa utang, itong isa naman ito para ito sa unprogrammed funds. Kung nawala yung ganong divide, unahin natin yung pag-cover ng budget deficit natin. Covering the program funds. Kasi priority natin yun, di ba?
Correct po, ma'am.
Okay. Sabi nyo nga, standby lang yung ano natin. Pero ang nangyayari, mas inuuna nating punuan yung unprogrammed funds. Hindi ba? Tama.
Kasi po, sa DBM yung nangyayari.
Kasi pinaghiwalay natin yung sources. Pinaghiwalay. Yun ang sinasabi ko na parang superficial lang. Just to justify the funding for unprogrammed funds. Iniiwas natin siya sa budget deficit. Pero talaga namang related yan sa budget deficit natin. Diba? Kasi lahat ng pang-cover natin sa budget deficit, inuutang din lang naman natin. Samantalang, yung mga nagko-cover ng UA, hindi natin yun inuutang lahat. Hindi ba? Meron tayong excess tax collection. Meron ding utang.
Meron din po, ma'am.
Kaya nga, pareho lang sila. Utang dito, utang doon. All right. All right. Has it happened that at some point in the fiscal year, the unprogrammed appropriations shall have already been fully funded, while our deficit still is not fully funded?
Ma'am, yung history po, hindi po lahat ng UA na pupondohan. In the past, I could mention...
hindi siya napupondohan lahat.
Yes.
Okay, mga ilang porsyento ang hindi napupondohan?
For example, yung 2023,
Yes, Chief.
out of the 807 billion na UA sa GAA, ang na total releases lang, I'm sorry, I have not complete.
Yes, it's
not
all
complete.
right.
So
I
it's
think
not
we all
complete, yeah.
deserve a health break. Chief Justice, I yield the floor to you. Thank you.
Thank you, Justice Ami. In view that it's already 12 o'clock exactly at the court's clock, let's suspend the proceedings. But in the meantime, Justice Kagi would like to ask question to the Solicitor General.
No, just to clarify, you were mentioning earlier about transferring program to unprogrammed. Sino ba talaga nagta-transfer? Is it the Office of the President when they prepare the NEP? Or is it Congress when they pass the GAA?
It is Congress, Your Honor.
So it's not the Office of the President. It's not DBM.
No, Your Honor.
So yung kaninang responses mo to Justice Amy, you were referring, these are not being transferred by the Office of the President. These
No,
are
Your
being
Honor.
transferred by Congress.
Yes, Your Honor.
And you're representing both?
Yes, Your Honor.
Okay. So moving forward siguro, baka we can clarify which hat we're wearing when we say, kasi nalilito ako sa mga responses eh.
Yes, Your Honor. Although, the Office of the Solicitor General represents po the position of the government.
I know, but the actual transferring
Yes, Your
of
Honor.
appropriations, just to clarify, is done by Congress, not by the Office of the President.
Yes, Your Honor. Yun pong kaninang mga nasabi.
Yung kaninang pinag-usapan. In fact, it was the Congress transferring the programmed appropriations proposed by the NEP into the unprogrammed that came out in the GAA, correct?
Yes, Your Honor.
Okay, yun lang. I just wanted to clarify.
Thank you, Your Honor.
As I said earlier, it's already 12 o'clock, so we'll suspend the session to resume at 1:30. Thank you.
the Honorable, the Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the Court is now in session.
Please be seated.
Justice Amy Lazaro will resume her interpellation.
The Honorable Representative of the DBM. The Secretary. The DBCC. DBCC. Okay, the DBCC. Chief.
For the record, we acknowledge the presence of our amici, Director Sudita Monsod. Thank you.
Yes, thank you, Chief Justice. Yes. Sir, has it happened that at some point in the fiscal year that certain projects under the unprogrammed appropriations have already been funded while our deficit remains not fully funded?
Yes, Your Honor.
Yes.
There are many instances like that.
All right. Because of the separate funding sources.
Yes, and
Yes.
also because these have been already requested to us, to DBM, and we have to check the documents if they're already complete. I'm referring to, for example, foreign assisted programs, so which, for example, they have already a counterpart funding, which is through loans.
All right. Has it happened that the deficit has not been fully funded at the end of the fiscal year?
At the end of the fiscal year, normally we would be hitting almost the deficit program.
Heating? What do you mean heating?
Hitting meaning reaching the program deficit.
Which means you, by the end, approaching the end of the fiscal year, you would have already fully funded the deficit.
Yep, the program deficit. Yes,
The program deficit. So it has never happened that the fiscal year has ended and we still have to raise the funds to fully cover the deficit.
Normally we would, as I mentioned early this morning, there was a target deficit of 5.6, and yet we even breached that target deficit. We even reached 5.7 deficit to GDP ratio. So even
Yes, that's one instance. How
Yes.
about the other instances?
other years, 2024, 2023,
Yes.
2025.
So are you saying that the funding for an unprogrammed appropriation, okay, is simultaneously done with the funding to cover the deficit?
Correct, ma'am.
Yes, and it can also happen that the funding for the unprogrammed appropriation would come earlier than the funding to fully cover the deficit.
Correct, ma'am.
Yes. Now, can you please lead? Soljan, would you like to answer? Okay, with his assistance, of course. Thank you.
Thank you, Your Honor.
Madam Solicitor General, can you please lead us to the wisdom that led Congress to make a distinction between the sources of funding for our deficit on one hand and the sources of funding for our unprogrammed funds on the other?
Your Honor, the sources of funding were based on the proposal by the President in the BESF that was submitted to Congress, in which it is our position is covered by the prohibition on the ceiling. The Constitutional Commission minutes, deliberations, would also tell us that the importance of not breaching it is because it is the executive that knows how much money it is able to raise, and therefore the Congress cannot drive the country into a spiraling deficit without giving due consideration to the sources of financing in the BESF. And may I clarify, Your Honor, based on the answer of our representative from DBCC, that the borrowings that define or that goes into the equation of the deficit target are based on a multi-year projection, and the wisdom or consideration by the executive with regard to which to fund, and also I would suppose because of the presentation of the executive to the Congress, that the consideration would be on the economic impact of funding or borrowing this much and funding the payment to the borrowing based on observing the deficit target that has been projected in a multi-year versus the unprogrammed appropriations to be funded and which will have an economic multiplier effect. So for example, housing projects would have a specific economic multiplier such that the Philippine government, when it decides to put its investment in a certain project, it has a computation as to how much jobs it will generate, how much contribution it will have to the GDP. And that's our submission, Your Honor.
Yes. So are you saying, Madam Solicitor General, that when a certain item, if included in the programmed appropriation, will breach the limits imposed by the Constitution, the convenient thing to do is to move it to unprogrammed appropriation?
Your Honor, that is our understanding of
Yes.
Working within the fiscal space that is allowed to the executive in the execution of the budget.
So in effect, there is a circumvention of the limitation because when it is in the programmed appropriation, there is a limit. But if you move it to the unprogrammed appropriation, sky is the limit.
Your Honor, it is our respectful submission that it is not a circumvention because what is being shown in the deliberations of the Constitutional Commission that the committed targets of the executive should not be breached is actually being observed. Number two, why do we not consider it as a circumvention? Because the Constitution also provides that the form, content, and manner of preparation will be prescribed by law. And this means that the power to define the manner of preparation and the content has been given to Congress.
Correct. That's why we go to the wisdom of Congress, okay, in moving one item from programmed to unprogrammed funds. And it is clear that the movement is motivated by the intention of the political department not to breach. Because the breach is applicable, the limit is applicable to appropriated, up to programmed appropriation, but not to unprogrammed appropriation. So the unprogrammed appropriation becomes untouchable. All right. So since we are citing the statutory authority granted by Congress to move the programmed funds into unprogrammed funds, among others for avoidance of the limitations prescribed by the Constitution. Can Congress, by law, actually merge the sources from which funding is taken for all its priority projects, for all the priority projects of the government, under one single category of programmed appropriations?
Your Honor, yes, that is possible, Your Honor. And if I may clarify on the use of the wisdom of the Congress, is that we refer that because the power has been constitutionally given to a branch, it has given it the discretion for its own judgment call.
Very well said, Solicitor General. Discretion that must be sound.
Your Honor, that is always our hope, that our leaders, especially those who have been elected, would make sound decisions. That is our hope, but based, and it is my respectful submission, on the separation of powers. If a power is lodged in one branch, although it is subject to the review of the Supreme Court on the actions on whether they have been committed with grave abuse of discretion, may I respectfully reiterate that we will also look for the standards by which this honorable court will evaluate the actions.
Yes, Madam Solicitor General, you are assured that the court will act in accordance with the Constitution in resolving this case, as we do in all other cases before the court. So I go back to my question. Can Congress, by law, actually merge the sources and all the priority programs and projects under one single category of programmed appropriations?
The answer, Your Honor, based on the position of the Republic, is that it is possible.
Yes. So what is the advantage to the Filipino people of this merger of funds and programs under one single category that is programmed appropriations? What is the advantage of that to the Filipino people?
Your Honor, if I may, based on our briefings, we have been made to understand that the flexibility that is needed by the executive has been there since time immemorial, and therefore that is the reason why even before the 1987 Constitution, there have been unprogrammed appropriations. So it refers to the speed and efficiency by which the executive can fund or address the programs, activities, projects that the Congress has already identified as important for the government.
So it is doable.
It is doable.
Yes, but you are invoking tradition and expediency.
Your Honor, by tradition, all I hope to emphasize is based also on the framework of our Constitution, which observes the separation of powers. We all know the responsibility of the Supreme Court as the one that has the final power to interpret the Constitution. However, in our daily life, the other co-equal branches have the responsibility to interpret as well the Constitution in accordance with how we understand it, and we will be limited by the Constitution itself. And that's why I try to give a historical context that it isn't specific to one administration, and that a co-equal branch has interpreted it in a particular way in order to also avoid a conclusion that it might be a weapon used by a specific administration. So only in the context of the coordinacy theory, Your Honor, that's the reason why I share the historical context.
Yes, Madam Solicitor General. So you're saying it's doable?
Yes, Your
Yes.
Honor.
Are you also saying that doing so does not generate any advantage for the Filipino people?
So, Your Honor, is your question whether what is the advantage of
Yes,
collapsing
yes.
it?
I'm not collapsing. I'm not
Or
for it.
merging?
Merging the sources, the funding, and merging the programs under one single category.
The DBCC representative is saying, well, it does not have a trigger, and that means that all will be funded. But again, the reason why the DBCC, the policy-making body, they have concerns or considerations with regard to meeting a deficit target. It has to do with our credit rating. It has to do with the economy.
Yes. So credit standing. It's okay. For program funds, we borrow. Correct? We
Yes,
borrow
Your Honor.
to cover funding, and for unappropriated or for unprogrammed appropriation, we also borrow money. So what credit standing is at stake when they are merged under one classification?
Your Honor, or maybe the technical expert may explain it better than
Yes,
I can.
please.
Thank you, Your Honor. I'll try my best. Well, normally, if you have only programmed, then that would be the one programmed expenditure. Then that would be the one that would require the borrowings, the deficit. But if you put more, like if you merge, including the UA and program appropriation, so you'll be having a bigger spending, and that would require bigger amount of borrowings.
Loans.
Yes.
Alam mo, may borrowing ka for program funds na 100 billion, and then sa unprogrammed funds 100 billion, it's a matter of addition. There's only one borrower, the Republic of the Philippines.
Yeah.
So bakit mo siya i-split pa?
Ma'am, if I may elaborate.
Yes.
Yung sa for the unprogrammed funds, unprogrammed appropriations na borrowings, we normally put it there at the NEP level simply because it has not been approved at the ICC level. So we would want...
ICC?
Yeah, ICC is the Investment Coordination Council,
It's a different ICC I have in mind.
Yes. Yes, Your Honor. So this is the one that is headed by DepDev, and they're the ones approving the ODA loans.
Okay yun.
Okay. Pero kasi yung pumapasok sa UA, ito po yung hindi nasasama sa
Alam mo,
NEP.
lahat yan matter of law eh. Law lang yan eh. Pass a law, di ba, merging the program. What's wrong with that? Tapos uutang ka, piecemeal. But in the end, pareho lang ang suma total.
Your Honor, may
Yes,
I, be
yes,
allowed?
Soljan.
Thank you. Thank you, Your Honor. One consideration that I am thinking of if we combine in only one, and that will be considered as programmed appropriations, then that means that we are asking the executive to commit to meet those targets, which in the first place
What
it
is
not
wrong with
able.
commitment? We are committed to the Filipino people. What's wrong with giving our commitment?
Your Honor, giving a commitment to a certain amount of revenue that it is able to earn. So that, for example, for a household, there will be basis as to what amount a family can project as its revenues, which will be based on its salaries or based on the historical result of their business. And even if they desire to earn more, but more often we could not ask for a commitment if it is really not based on something that they could deliver.
Yes, we can commit only what we can earn and what we can spend.
Yes,
Correct.
Your Honor.
So it also prevents overspending. All right. I'll go to the next. Your excuse, sir. Thank you. Madam Solicitor General, who sets the target revenue at a given time?
The target revenue is the DOF or the DBCC. Your
Siya
Honor.
ulit?
Yes po.
Okay. Yes. Would you like to come back? All right. Thank you. Do you take into consideration, sir, the total cost of program appropriations when you set the target revenue? Yes?
When you say total cost
Yes.
of appropriation,
Total cost for programmed appropriations when you set the target revenue.
yes,
Yes,
ma'am.
of
Because
course.
we have a tolerable level of deficit that is also being planned for each year.
All right.
So, and then DOF, Department of Finance, would tell us how much they could only afford to collect in a given year, for example.
All right. So, is it possible that the target revenue would be set lower in order to create an excess revenue collection?
It would be difficult for me to answer that
Yes.
because that's actually the activity of the Department of Finance. What they would be doing at the DBCC would just be presenting their figures and for the economic managers to approve those numbers.
All right. So,
But
as an
to,
expert as well in economics and budget, is that possible? That to adjust the excess or create an excess of revenue collection beforehand, the target is already lowered. Can it be done? It's theoretically. I'm not saying you're doing it.
Yeah, meaning they can target a lower standard, lower bar, so that they can breach it anyway.
Yes, so that
down the
that
line.
can be done. Yes.
Theoretically, yes,
Yes.
Your Honor.
In order to create an excess revenue collection, correct? To cover the
Either to finance the unprogrammed
appropriation
or to reduce the deficit.
or reduce the deficit. Which one comes first?
It depends on if, for example, there's a certificate. Let's say if we are in the month of May, and there's a budget request coming from the DBM to finance an unprogrammed appropriation item, then we would work on the submissions.
So it's the DBM that determines
If
which one should be given priority, the programmed items or the unprogrammed items?
we would be working on the availability of certified excess revenues, Your Honor.
All right.
So if there are no certification coming from the Bureau of Treasury, then we simply say no to those implementing agencies who are requesting for unprogrammed
So
appropriation.
theoretically speaking, excess revenue collection can be generated because it is subject to adjustment by setting a lower target revenue.
But for planners, Your
Do
Honor...
not change your answer.
No. Yeah.
You already said
But
yes.
part of good planning and foresight is to really look for the more precise
Correct.
number.
Yes,
of,
I'm for foresight.
Yes.
But my question is focused on whether this can be done to generate excess revenues to cover unprogrammed appropriations. Yes. So,
Your Honor,
yes, please.
Because he was looking at me, I feel
Okay.
obliged to say something. Theoretically, yes, it is possible, Your Honor, but I think I would like to continue your thought that the planners also have a mandate as to performing with the best interest of being the experts and the technical experts of the executive.
Yes. Very well said, Madam Solicitor General.
Thank you, Your Honor.
So, from what I gathered from the submission of the Solicitor General earlier, the practice is once excess revenue collections have been identified to exist for, let us say, the first quarter, then this excess would already be applied to unprogrammed appropriations, regardless of whether the full amount for programmed appropriations have already been realized. Is that correct?
Yes, Your Honor. So the explanation to us was that, for example, there are certain revenues that may still be collected in the second quarter, third quarter, fourth quarter, and therefore has to wait for the timing when the programmed appropriations can be funded. But may I also add to that the advantage of being in the programmed appropriation is after the GAA, it has already the allotment order, which means that the government has actually funded the programmed appropriations, while on the other hand, the uncertainty of the unprogrammed appropriations is based on the fact that then they have to check if there is excess to be certified by the Bureau of Treasury, and they have to obtain the SARO, which are a couple of steps more and uncertain as to the timing.
Okay. I want to go back to your story about the family. Yes, the family budget that you presented during the first day of the oral argument. So, using the family budget that you presented during the first oral argument. So, ang ibig sabihin nito, imbis na siguraduhin na may sapat na pondo para sa pagkain at tuition fee at upa ng bahay, dahil lang nagkataon na nanalo sa loto si nanay, gagamitin ang panalong ito sa pamamasyal sa Burnham Park. Kahit hindi tiyak kung may panggastos ang pamilya para sa pagkain, tuition fee at upa sa bahay sa mga susunod na buwan. Hindi ba nangyayari yan sa pamilya?
Yes, Your Honor. The analogy that we tried to include in our opening statement, of course, it reduces the situation into much simpler terms, but we were hoping to highlight the point of what are the regular expenditure that cannot be made dependent on an uncertain trigger versus the list of projects for the family, although important, will not be sure that can be funded. And that is from the perspective at the point of planning or passing the GAA.
Opo, Soljen, ito napakasimpleng senaryo lang. Hindi ba? Si nanay at si tatay parehong may hanap buhay. Ang sweldo nila ang pinagkukunan ng tuition fee ni kuya at ni bunso at mga pagkain at iba pang upa sa bahay. Okay. Yun yung program funds, hindi ba? Si kuya, yung tuition fee niya, nabayaran na ni nanay. Okay. Pero si bunso, wala pa. Hindi pa nababayaran. Then, tumaya sa loto si nanay, nanalo ng 10,000 pesos. Imbis na gastusin niya yun para sa tuition fee ni bunso, namasyal sila sa Burnham Park. Bumaba sila sa terminal ng Victory Liner sa katapat ng Supreme Court. Bumili pa sila ng strawberry jam at saka ubi jam. Okay. Si bunso na-depress. Kasi bakit inuna pa yung pamamasyal? Samantalang yung tuition fee ko hindi pa nababayaran. Ngayon, sabi ni nanay at ni tatay, okay lang bunso kasi alam mo nakaprogram ka sa sweldo namin. Dapat kailangan din nating mamasyal. Anyway, windfall naman to, hindi natin inaasahan. So gastusin natin para ma-enhance yung ating quality of life. Magkaroon tayo ng work-life balance. Pagdating ng susweldo naman kami sa susunod na buwan, pareho silang workers sa pabrika. And then sa susunod na buwan, pareho silang na-lay off kasi nagsara yung pabrika. Wala na ngayon tuition si bunso. Lalo na na-depress si bunso. Tama ba si nanay? Makatarungan ba yung nangyari kay bunso?
Your Honor,
Oo.
Maraming salamat po dun sa paglalarawan para medyo kitang-kita po yung punto po natin. Ang akin pong maiisagot, yun pong sa punto de vista po ng executive at saka ng Congress, pagkalabas po ng GAA, funded na po dahil nga programmed siya. Kaya kung matter of time po, baka po yun yung isang issue na kahit na committed yung target dahil baka maaaring hindi magkatotoo, kung pumasok na ang cash, dapat doon na gastahin sa program.
Tama yan.
Opo.
Kaya, ang tingin ko, dapat lahat ng sources of funding iisa lang, one fund. Hindi ba? Bakit pa paghihiwalayin yung appropriated programmed appropriation? Iba yung kanyang panggagalingan. Iba rin yung panggagalingan ng unprogrammed appropriation. Ang gusto lang naman natin dun, ang gusto ng pamahalaan natin ay hiwalay sila para yung limitation para sa program, hindi ko i-apply dito sa unprogrammed. Hindi ba? Tapos, in the end, naku-confuse tayo kung ano yung priority natin talaga. Inuna pa na talaga yung pamamasyal kesa sa tuition fee ng bata.
Your Honor, in our briefing po, merong paliwanag po sa amin ang DBM na aside from when we say, did you fund a project? Our attention was called and said that there are two steps. One is issuing the allocation, the allotment release order, and the number 2 is the cash. Pagka po dumating na yung cash. At pag po dumating yung cash, meron pa po silang mga
Hindi yan
cash.
Gcash. Hindi.
Hindi po. Pwede rin siguro. Yung pong cash, meron din sila pong mga policy dahil ito na po pumapasok na yung fungibility. Kaya maaari pong theoretically na una ring ibigay yung cash kahit na po nauna na yung allotment release order talaga, pero kung cash ang pag-uusapan na may pumasok, ay baka po mas mailarawan niya ng mas maayos.
Sige nga.
Your Honor. So, tama po yung sabi ni Solgen. So, nag-release kami, DBM, ng SARO, authority appropriation, release order pa lang po yun, wala pong cash yun. Pero yung certification ni BTR is already cash, a windfall already. So, by that time na natanggap ng agency yung SARO, they can contract it out, the project, but not necessarily paying out the cash.
Bakit sinasabi mong windfall?
Yung windfall po galing sa BTR na meron silang excess revenue na. Yung
Excess revenue without quarterly. No? We don't take into consideration the collection for the following quarters.
Normally, actually, ang certification nila would happen towards the latter part of the year. That's actually by experience, the certification of excess revenue.
So, wala bang nai-implement na projects under unprogrammed?
Sa umpisa.
Sa simula.
Simula. Totoo po yun. That's actually the problem also when there is...
So, lahat ito nai-implement lang after the fiscal year?
No. After the certification of BTR, which happens towards the latter part of the year.
Correct.
So
hindi ba totoo na yung excess ay ina-announce natin o kino-consider natin by the end of each quarter? Hindi ba ganun yon?
Minsan walang excess revenue sa first quarter.
Paulit-ulit yung sinasabi kasi, di ba, na per quarter yan Per quarter, hindi yan by the end of the year. There's no problem kung by the end of the year. So, everything is accounted for. Hindi ba? Na talagang meron kang excess. Kasi, you already considered, the funds that were not raised, the revenues that were not raised, at least a portion of it during the second quarter, third quarter, and fourth quarter. Pero from my understanding, you don't do that. What you do is you determine the excess per quarter.
Your Honor, if I may po.
Yes.
I think your recollection is correct because I think in the first or the second oral session, we were discussing the Araulio versus Aquino, and we were clarifying the concept that was explained in the motion for reconsideration, which is a quarterly report. And then subsequently, so we also asked the Treasury as to what do we have like quarterly targets with regard to the unprogrammed appropriations, and we were made to understand, in fact, so for example, for dividends, that they are going to certify that there is excess if the annual target. So we also thought that it's like a quarterly, but they corrected us in saying that the target, for example, for the dividend, if it's 20 billion, and that's the annual, not the quarterly. If and when it exceeds that, that's the only time that they will certify. We also thought that it was like a quarterly target, but they...
So they certify all at the same time, after the fourth quarter, or by the end of the fourth quarter?
No po. Opo, not necessarily po. In fact, I think in the interpellation of Senior Associate Justice Leonen, he spotted that there was like a certification in the first quarter, and the representative from DBM clarified that it referred to a FAPS or Foreign Assisted Project.
So are we saying that the priority programs, yung mga projects, flood control and all, they all happen at the same time? By the end of the quarter, of the fiscal year? Because that's the only time that the bulk of the funding shall have been raised?
Based on the statement of our representative from DBCC, it's usually towards the second semester of the year, and the SARO will be good for 2 years, Your
So
Honor.
nagre-release na rin tayo ng pera even before the end of the fourth quarter? Yes?
Ma'am, possible na makapaghingi na after the SARO, we will be releasing the NCA when they require already that payment for their, for example, suppliers. But yung sinasabi ni Soljan kanina na once there was a certification from BTR, so money has already arrived, but it's very possible that the money that is there as a windfall may not be used for that.
Why do you use the word windfall?
Windfall meaning not program revenue, but it's
That's another
an excess,
name for...
excess revenue, you can say.
Okay.
Excess revenue, sorry, Your Honor.
Excess revenue.
Excess revenue. So this excess revenue that is in cash, since cash is fungible, very possible that this will be used for programmed items. And so ang mangyayari, this implementing agency who requested for money from UA might be asking for that money next year pa. So when it comes to attention to what is really more important project at a given period of time, the fact that the cash was already there, very possible that the cash was made to attend to those, we can say, social protection activities.
All right. So in August, your excuse again. Would you like to just stay there in case you are needed again? You don't mind, or you mind? You mind or you don't?
Your Honor.
Huh? Would you like to sit?
Thank you.
Sit down. Okay. In August of last year, Deputy Speaker and Antipolo Representative Ronaldo Puno made a public pronouncement that the House leaders noted certain problematic provisions in the 2026 National Expenditure Program submitted by the President to the House. Among others, he mentioned the zero allocations for multi-year programs, as well as provisions allocating budget to government projects that were already finished. According to Representative Puno, the House leaders recommended to Speaker Martin Romualdez that the NEP be sent back to DBM because of these problematic provisions, so the executive will be able to address them accordingly. Let's watch this video of Representative Puno.
Party leaders in the House of Representatives recommend sending back the 2026 National Expenditure Program to the Department of Budget and Management due to issues in allocations. In a press briefing on Wednesday, September 3, Deputy Speaker Ronaldo Puno says the party leaders already made a recommendation to House Speaker Martin Romualdez. The 2026 National Expenditure Program contains the proposed budget for next year.
We have decided as a group to recommend the return of the 2026 national budget to the DBM because we do not know how to deal with it. We have to practically redo the entire submission to us, and we do not want to be suspected of any untoward action. We don't want it to appear that we are not accepting the rightful recommendations of the DBM, and on the other hand, we do not want to be accused of also of replacing or amending by errata a huge portion of the national expenditure program that they have submitted to us.
All right, Soljan. As it was, the plan to return did not push through. Per subsequent pronouncement of the House party leaders sometime in September 2025, they said they already dropped the move to return the NEP to the DBM after the DBM promised to address the problematic provisions. I suppose this was done, the reason the 2026 GAA was enacted. Okay. My question is, were similar objections coming from the House also raised upon the receipt of the NEPs for 2025 and 2024 GAAs?
Your Honor, may I ask for the representative of the DBM to answer the question, Your Honor?
Who?
ASEC Angel.
Okay. The angel may come. ASEC Angel. Yes, ASEC Angel. What is your answer?
As to the return, I think the best thing to define would be the budget cycle, which is divided into 4 phases, with constitutional deadline, particularly on the submission of the President to Congress of the BESF. So at the point of September, it would already be past the 30-day deadline after the SONA for the executive to submit to the Congress the BESF. So at that point, we were already at the budget authorization phase. So with the exercise of the power of the purse, it would be the legislative who will have the power and the authority to discuss and revise the budget as submitted, subject to the constitutional limitations.
So, are you saying ASEC, Karen? Is that correct?
Angel.
Angel. Okay, Angel. Are you saying that Representative Puno his concerns regarding the so-called problematic provisions were not addressed by the DBM?
As far as I know, Your Honor, they did not pursue the recommendation to return the budget to the DBM. I think in recognition of the budget cycle po.
All right. So, your excuse,
Thank you po.
Attorney Angel, and the Solicitor General in the meantime. Thank you.
Thank you, Your Honor.
Okay. May I call on Attorney Soriano and Peña, the lawyers for Congresspersons Erice and De Lima?
Good afternoon, Your Honors.
Yes, good
afternoon, Your
to
Honors.
both of you. Okay, in the petition that you filed, you posit that the 2024, 2025, and 2026 GAAs are unconstitutional because Congress increased the unprogrammed appropriations over and above what was included in the President's budget. Each of the petitions praised that the provisions on unprogrammed appropriations in the 2024, 2025, and 2026 GAAs be declared unconstitutional. Okay. Assuming the court grants the relief you seek and invalidates the provisions on unprogrammed appropriations, what would be the practical effect of that pronouncement on the operations of our government? Attorney Soriano first.
Your Honor, the practical consequence of declaring it unconstitutional would be such concept will be declared void and annulled, Your Honor, and that in the meantime, Your Honor, only those programmed appropriations will be considered constitutional, Your Honor. In any case, Your Honor, any needed appropriation for emergency funding, as suggested by some of our amici curiae, Your Honor, can be through a supplemental budget, Your Honors.
Okay. Can the government be compelled? Your turn, Attorney Peña. Can the government be compelled to refund the entire budget earmarked for unprogrammed appropriations?
Your Honor, we respectfully submit that the government will not be, cannot be compelled to refund that amount pursuant to the operative fact doctrine, in which provides, Your Honor, that since the 2024 and 2025 budget has already been spent and terminated at the end of the fiscal year, and at that time, Your Honor, pursuant to the presumption of constitutionality of statutes, they were still valid at the time, so they will remain effective, and it is only what we hope, Your Honor, for the 2026, the unprogrammed appropriations, that part be declared as unconstitutional, Your Honor. And if we may just clarify, Your Honor, for our submission, we submit, Your Honor, that it is only the unprogrammed appropriations chapter in the 2026 budget that is unconstitutional, because compared to 2024 and 2025, it is only in 2026 that the Congress did not actually increase the budget in the GAB from the NEP submitted by the President.
All
Thank
right.
you, Your Honors.
So, you also negate any ensuing liability on the part of the implementing agencies and or the people who implemented it?
Yes, Your Honor. Specifically, if we're talking about criminal liability, we follow Pimentel, Your Honor, the landmark decision.
Who said criminal liability? Why are you thinking of that?
Because, Your Honor, due mainly on the scale and magnitude of the amount spent, Your Honor, it will be reasonable to think that there is criminal liability, but in that decision, it was also explained by this court that the avenue for that would be in a different forum, Your Honor. But as to civil liability, that is actually one of our recognized realities, Your Honors, that the amount is so big that no one or no group, even of several people, which makes the injury irreparable for the Filipino people, Your
So
Honors.
your position is how to move forward henceforth.
We still hope, Your Honor, that the Honorable Court will rule that the 2020 unprogrammed appropriations under RA 12314, the 2026 budget, will be declared unconstitutional, Your Honor. And then
It's not affected by mootness.
for the 2026, not yet, Your Honor, because
For
there's still time.
2024, 2025, is mootness applicable?
Mootness will be applicable, Your Honor, but the court is not prevented from ruling on the constitutionality of the 2024 and 2025 budget on the ground of mootness because the exceptions exist in this case, Your Honors.
Such as?
Such as, first, Your Honor, when there is, the issue concerns a grave violation of the Constitution, which we submit exists in this case. Second, when the issue is of paramount importance, also present, Your Honor, because this involves the national budget. Third, Your Honor, when the principal will guide the bench, the bar, and the public, which we all need for the subsequent budgets. And lastly, Your Honor, when the issue is capable of repetition yet evading review, and because the budget terminates within 1 year, it also fulfills the last requirement, Your Honor.
Yes, it is your position, together with the other petitioners, that unprogrammed appropriations have no place in the General Appropriations Law. How then should the government address unforeseen events, contingencies, or matters that require emergency funding or priority funding in a particular fiscal year? Yes. Can you answer
Yes,
that,
Your Honor.
Attorney
As
Soriano?
mentioned earlier, Your Honor, these circumstances can be addressed through a supplemental budget, Your Honor. And in any case, their emergency funding is also provided under the program appropriations, Your Honor, such that there are programs, for example, disasters, Your Honor, or any international or medical crisis, Your Honor. There are already sufficient appropriations in that sense, Your Honor, within the program appropriations, Your Honor.
Did you mention supplementary budget?
Yes, Your Honor.
Yes. You may now sit down. Thank you.
Thank you, Your Honor.
I suppose the Honorable Solicitor General has rested for a while.
Thank you, Your Honor.
May I recall the
Thank you, Your Honor.
Honorable Solicitor General?
Thank you, Your Honor.
Thank you, ma'am. From the DBM and the posted briefer by Congressional Policy and Budget Research Department of the House of Representatives, it was reported that the utilization rate for 2023 UA was 70.4%. Utilization rate for 2024 UA was 67.5%. You're aware of this?
Not exactly with the, not the exact figures, Your Honor.
Yes. Who do you want to call?
I would
Lifeline
suggest
or-
ASEC Angel for
ASEC
DBM.
Angel, please. All right.
Your
But
Honor.
maybe yes, what is your answer?
The date,
ASEC
Angel po.
Angel.
The data that I have on hand would be the 2024, 2025, and the 2026 unprogrammed appropriations, which presents the total excess income certified and the total salary releases, which means that I would be able to give the data as to how much was released coming from the unprogrammed
Yes,
appropriations.
would you confirm that as reported by your office and by the Congressional Policy and Budget Research Department of the House of Representatives, the reported utilization rate for 2023 UA was 70.4%, while in 2024 it was 67.5%. Is that accurate?
If it was posted on our website, I would say that it's accurate.
Yes.
But to clarify, Your Honor, the utilization rate could either be utilization meaning obligation over allotment or disbursement over obligation. So I would need to, if we allowed, we will be able to submit the data, Your
Okay,
Honor.
please do.
Yes.
All right. Madam Solicitor General, can you lead us to the wisdom that led the Congress to enormously increase the amount of unprogrammed appropriations compared to the proposal of the President in the GAA 2024? To recall, the President proposed 281.9 billion for unprogrammed appropriations, which Congress increased to 731.4 billion. So what was the wisdom underlying that radical change, radical increase?
Your Honor, I don't have the answer with regard to the soundness of the conclusions that drove them to increase the unprogrammed appropriations by that amount, Your Honor.
I think that was already posed by Saj Marvick before. You still hasn't consulted. You still haven't consulted
Yes,
with
Your
your
Honor,
clients on this.
I respectfully share with this honorable court because we have a different way to appreciate the wisdom, in the sense that when we say that it is it depends on the wisdom of a co-equal branch, we interpret it that it is a judgment call, and when it is a judgment call, then we live and die with a judgment call of
You
a,
live and die with a judgment call.
and the limits, Your Honor,
Yes.
will be the textually demonstrable constitutional limitations, Your Honor.
But it was so enormous that it was hard to ignore.
Yes, Your Honor. I think that most of our kababayans would, or maybe all, would not want decisions whose soundness is not evident, and that's why the only way that I could really represent as the position of the respondent is that the Constitution also provides for the mechanisms as to how to correct if we elect leaders who we don't agree
After the
their
fact.
decisions.
After the fact.
Because
Yes.
and because, Your Honor, of also the design of our constitutional framework and our democratic framework, we have many objections as to our political situation, but the two political branches, we elect the leaders.
Yes, of course. But I was just hoping that the change will come from the leaders themselves. Okay. And that I am hoping as well that our leaders will learn from this.
Yes, Your Honor. If I may say that we would share also with your hope, and that's why in the 2025 GAA, I think tama ba? Doon nagkaroon ng veto si President BBM,
Yes.
and then in 2026 lalong lumiit na po ang unprogrammed appropriation. In parallel, we are also monitoring the movement of the bills that are filed in Congress and Senate with regard to the budget law, which we had previously. All throughout the constitutions have been accompanied by a budget law, and this budget law would actually legislate what is that deficit target, what is that range, to define really what is the fiscal policy which will guide, and I think that was also shown by former Congressman Salceda, because he was the author of such budget
Yes.
law. So we're hoping that there's also a self-correction with regard to the respondents, also in reaction to how the public has expressed their emotions with regard to the
Very
GAA.
well, Solicitor General. During the oral arguments in the PhilHealth case, the court noted certain items which seem to have a duplication of funding, such as, can we flash the table? Yes, such as the maintenance, repair, and rehabilitation of infrastructure facilities, the payment of right-of-way, management and supervision of peace process, and priority social programs for health, social welfare and development, higher education and technical and vocational education. So I focus on the first, maintenance, repair, and rehabilitation of infrastructure facilities, or what we call the routine maintenance of national roads. This specific item was already allotted a total of approximately 2 billion under the program appropriation. Yet, it was still included as a project to be funded by unprogrammed appropriations in the 2024 GAA. Why was there a need for double funding, especially given the less than 100% utilization rate for programmed appropriations?
Your Honor, based on our briefing, the explanation to us was, again, with regard to the difference between a committed target and committed funding. So that means that we were given copies, Your Honor, of requests from agencies. So for example, if the OSG requests for, let's say, 2.5 billion pesos for our fund, we were just given 1.9 billion. But during the presentations to Congress, when we were asked if the 1.9 billion is enough, we would present that we have other programs that were not funded, and if based on their discretion, they are also important to be funded, then they could add on. So sometimes the amount, Your Honor, a portion, a big chunk can be committed, but they still believe that it is not enough, but the funding source should be something that has to be based on a trigger.
Yes, can't the DBM provide the funding, at least the figures for specific fundings which were already submitted to Congress?
Yes, Your Honor, the NEP, so it's part of the required submission by the President to Congress, but it is just a recommendation to Congress, and therefore the GAA, when it comes out, sometimes it adopts and sometimes it also amends or replaces
Yes.
with other projects.
All right. Now I come to my next point. If a particular project will only be funded under the programmed appropriations in its entirety without including it as well under the unprogrammed appropriations, would the government run the risk of violating Article 6, Section 25(1) on the that Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget?
Your Honor?
Yes, that's my hypothetical question. If the project, a particular project, like OSG, I am from OSG and I love OSG. By the way, advance happy anniversary.
Thank you,
to
Your
you,
Honor.
to the OSG, which happens to share the same anniversary date with the Supreme Court
Happy
of the
anniversary
Philippines.
also. We
We're
share-
all we're both celebrating our anniversary.
125th.
125th on the same day.
Yes.
July 11. I congratulate you also.
Thank you, Your Honor, and
Solicitor
happy
General,
anniversary as
and
well.
your hardworking men and women in the office of the Solicitor General.
Your words are uplifting, Your
Yes.
Honor. Thank you.
Yes, our admiration and recognition of you being learned in the law, okay, proceeds from our recognition that the Solicitor General is among us. You are the 16th Justice of the Supreme Court. Okay.
Thank
Would you like
Your
to be
Honor.
the 16th or the 15th?
There has to be a trigger, Your Honor.
Parang mas madaling i-trigger yung unprogrammed funds, no, Soljan? But you have all our respect and best wishes.
Thank
for
you very much,
and
Your
the
Honor.
Office of the Solicitor General.
Thank
and
you.
by the way, thank you for the invitation.
Yes, but we have a very simple celebration.
Yes.
Coming from the order of the
Yes,
President.
but please understand if we cannot go. With heavy heart.
It's already an honor to be sending the invitation, Your Honor.
Thank you. So, if a particular, so what is your answer to that? Does it run the risk of violating the Article 6, Section 25(1)?
Your Honor, if my understanding is correct, if it goes to the programmed appropriation, then
It will violate.
It will be covered by the prohibition on breaching the ceiling.
Correct.
But maybe the limitation that the executive will tell us is it's the fiscal space that they can just move within.
It's like a parking space, right?
Yes,
The
yes, Your
cars
Honor.
should move. move out of the parking space. So
Yes, Your
other
Honor.
cars can park.
Yes, Your Honor. So the choice really of what to put in the programmed appropriations, which the government,
So is your answer to my question a yes?
it will, if it goes to the programmed appropriation, Your Honor, it will be covered by
It will
the breach.
avoid. Yes,
It
but
will
if it is moved to unprogrammed, it can avoid, right? The prohibition under Article 6, Section 25(1). Because according to your submission, only program funds are subject to this limitation, but not unprogrammed appropriation.
Yes, Your Honor.
Yes.
I mentioned a while ago that this provision includes the phrase for the operation of the government, and it is our position that historically there is the executive department has a working definition of what are the expenses that are for the regular recurring expenses which cannot be made dependent on uncertainties.
Yes. So it is clear that one of the reasons why appropriations items under programmed appropriations are moved to the unprogrammed is to avoid a clash with Article 6, Section 25(1). Yes. So, in the same manner, it avoids a collision with Article 14, Section 5, Paragraph 5, which states that the state shall assign the highest budgetary priority to education. What is your take on that, Madam Solicitor General?
Your Honor, if we say that moving to unprogrammed appropriation is to avoid the constitutional requirement for the ceiling, I'm not prepared to make that conclusion, Your Honor, because by moving it to the unprogrammed appropriation, then it becomes uncertain. It's not like the GAA items where when it is passed, there is already an allotment
So is your
request.
answer the same as your answer with respect to Article 6, Section 25A, that moving the item from program to unprogram actually prevents violation of Article 14, Section 5, Paragraph 5, that the state shall assign the highest budgetary priority to education? Because if these items, if we don't create what you call fiscal space, then the total of the budget under programmed may exceed the limit under Article 14, Section 5.5.
Your Honor, if I may be allowed to confer with the DBM Secretary, because the other provisions in the Constitution, there are 4 budget documents that are submitted, and that's why in one constitutional provision, it specifies the budget of expenditures and sources of financing, which refers to the BESF. Now, maybe I am surmising that this Article 14, Section 5 will have to refer to all, and if I may confer, Madam, Your Honor.
Yes, please. You may call on the angel. ASEC angel. Tatapos. Chief, tatapusin ba natin? 3:30. Okay. Ha? Page 9. Uy! Page 8. 16 na ako. 16. 30 na lang. 3:30 pero hindi ko matatapos. Depende kung ano sasagot na yung mahal mo.
So based on my discussion with the team, the provision that you just showed refers to budgetary priority, not necessarily the highest budget. I think that was the position that was presented by the OSG in the PhilHealth case as well. And ASEC Angel also clarified that this provision refers to the programmed appropriations.
There is no intention to evade the prohibitions under the two articles of the Constitution, the two provisions of the Constitution. There is no intention to evade.
No, Your Honor.
Violation.
No, Your Honor.
Yes. Are you aware of the cases of Gingona and Philconsa on the application of Article 14, Section 5, Paragraph 5?
Not readily, Your Honor. May I ask if...
All right.
is my-
Yes. Please study and perhaps you can include that.
Yes, Your Honor.
All right. But I would like to inform the good Solicitor General that in these cases, the Supreme Court said that there is no automatic violation of the Constitution when the government, in the exercise of its discretion, to place, prioritize programs and projects, will assign the biggest chunk of the budget not to education, but in these two cases, to foreign loan payments of the government.
Yes, Your Honor, we will
All right.
study.
Yes.
Thank you.
Thank you. Now, let me direct your attention to the President's veto message in relation to the 2026 GAA, particularly the following items under the unprogrammed appropriations, which he vetoed. Let's move on to the President's veto message. All right. In his veto message, the President noted that the scheduled increases in benefits of our civil servants, including our military and uniformed personnel, are part of programmed expenditures and will not be affected by the veto of the pertinent purpose of the unappropriated appropriations. The same is also true for the government's counterpart funding for ongoing foreign-assisted projects that are lodged within the concerned departments to ensure continuous implementation of our flagship projects that will provide greater benefit to our people. Likewise, insurance of government assets and interests may continuously be funded using available agency appropriations or, if necessary, to be augmented through other available sources as may be determined by the Department of Budget and Management. So, is this veto message of the President consistent with the nature of unprogrammed appropriations, which you stated to be standby appropriations, but may be included under both programmed and unprogrammed appropriations in the same GAA? I suppose the President was, in his veto message, was shunning. He is disagreeing and noting keenly the double funding under the programmed and unprogrammed funds.
Yes, Your Honor, I would agree, which also shows that the framework of passing the budget has also its own check and balance. The President proposes, Congress deliberates, passes the GAA, and then the President also has the power to veto.
I just noticed that for the first time, the President noted the double funding. Yes, and use that as a ground, as a reason to veto certain items that have double entries in the GAA.
Yes, Your Honor.
I think that is a laudable exercise of wisdom by the President.
Yes, Your Honor.
And I just wish that the President also saw it with respect to the GAAs in 22, 23, 24, and 25. But it's not too late. All right. So, if on the basis of the proceeding from the veto message of the President, there are earmarked funds in the program appropriations to cover the government's program and projects under the unprogrammed appropriations, whether urgent or emergency. What do we need unprogrammed appropriations for? When the President himself already noted the double entries that are not commendable, to say the least.
I think, Your Honor, the political branches have been very attentive as well to the reaction on the 2023, 2024, and that's why both the executive are also introspective and reflecting as to which can be corrected on their own, and the same with the Congress, Your Honor.
Yes. Thank you for that. Now, purpose number 1, and this is reflected in the GAA, for unprogrammed appropriations, referred to strengthening assistance for government infrastructure and social programs. SAGIP. It had the highest allotment under the 2024 GAA in the amount of 225 billion pesos. Since the fiscal limit imposed on the programmed appropriations does not apply, according to you, to unprogrammed appropriations, Are we saying that unprogrammed appropriations are superior to programmed appropriations?
We reach a different conclusion, Your Honor. Again, in terms of the certainty and in the certainty of the programmed appropriations, that after, if they are part of the programmed appropriations, then for sure they have the allotment release order, while on the other hand, the unprogrammed appropriations are less, definitely not superior in the sense that they will have to obtain the SARO, they will have to go to the executive department in order to wait.
But they have no limitations.
The limitation, Your Honor, is with regard to the...
They are not subject to the limitations in the Constitution.
in terms of the amounts, Your Honor.
Yes. Yes, they are not subject. So in that sense, it is superior to programmed appropriation. Now, with respect to SAGIP, what are its specific covered activities, objects of expenditure, or eligible programs?
Your Honor, if I may request for ASEC Angel to
Yes.
give the details
Yes,
of, under
please.
SAGIP.
Yes.
Your Honor, the SAGIP, previously named SIP-SIP,
SIP-SIP.
SP. Hence the change in name, Your Honor.
Yes, why?
The SAGIP, previously named SIP-SIP, was cover the same thing. Both would be, the two would be the social and the infrastructure projects.
So what's in a name?
I think to give the background in the change of name, there was a similar reaction when we called the purpose SIP-SIP in the Senate hearing. And after that, the DBM saw it fit to remove
But it's
the negative.
one and the same.
Yes. Your
Assigned with another name.
Yes, Your Honor.
So there is something in a name.
There could be a negative connotation to a name. Your Honor.
SAGIP sounds more decent.
Yes, Your Honor.
Yes? All right. So, yes, can you please walk us through the specific covered activities of SAGIP?
There's no specific list that will define what SAGIP can cover. The limitation is in the name. It covers social and infrastructure programs of the national government.
You know, that's my problem, actually. It's also your problem.
We note that in 2014, during the Supreme Court deliberations on the same subject, SIP-SIP was already present in as a purpose under the unprogrammed appropriations.
All right. So, doesn't it strike you as a blanket clause?
It may be considered as such.
Yes. Which can include any item one can think of under the sun. Yes?
If they can be considered as social or infrastructure
All
projects.
right. So what infrastructures projects are not social in terms of impact on the lives of the people?
I submit, Your Honor.
Yes. So may I ask the Solicitor General, or maybe you na, please continue, ASEC Angel. What items are excluded from this clause?
Personal services, so pangsweldo po, that's not covered under this.
Because they are regular, correct? They are regular items in the programmed appropriation. Definitely they are not included, correct? So,
Yes, Your
Aside from the regular operational or maintenance items in the GAA, can you think of any item under the sun that is not included in this sagip blanket clause?
It could, I'm just scanning the list of purposes, Your Honor, under the UA, and one such purpose could be the refund of service development fee for the right to develop the Nampedai property in Tokyo, Japan.
Ano dun ang hindi kasali? It's a blanket clause. It's a catch-all clause. Alam mo, bagay na bagay siya sa pangalan niya, sagip.
Sasagipin niya.
Sasagipin. O, sagip talaga. Yung hindi makasama sa iba, sasagipin na lang. Okay, so, what government agencies are implementing sagip?
I believe that DPWH had releases under sagip, as well as DSWD.
Yes, how much in 2025 was released to DPWH in the 2024 and 2025 GAAs? How much? And for what purpose?
For this, under the unprogrammed appropriations,
Yes.
Your Honor. If I may be allowed to get my reference notes.
Yes, please. Thank you.
Your Honor, in 2025, the total amount released for sagip is 51,969,141,532.
To DPWH?
No, Your Honor. I'm sorry, I am not accurate. Under the DPWH, in 2025, the sagip was released to DSWD, PhilRice, DOJ Bucor, DA OSEC, and DepEd OSEC, and DOH OSEC. There's no DPWH in 2025.
In 2024?
In 2024...
But DPWH infrastructure projects were covered under the program? Yes.
Definitely, Your Honor.
Okay, definitely. How definite?
The locally funded projects of DPWH are part of the program.
All right, in
appropriations.
2024, how much of the unprogrammed appropriation was allotted to DPWH?
A quick addition, Your Honor, leads to it's around 130 billion, 130 billion pesos under sagip for
much?
DPWH.
How much?
130 billion, Your Honor.
130 billion. Okay, over and above the item under the programmed. Yes, how
Yes, Your
much?
Honor.
Under the program for DPWH.
I don't have that data with me, Your Honor. I will.
All right, can you
allow
submit
we can
it next time?
We will,
Yes.
Your Honor.
Thank you very much, Chief Solgen and the Solicitor General, and yes, Attorney Angel. How
Thank
can
you,
I
Your Honor.
forget Angel? Yes, Chief. Yes, Chief. May I yield the floor to the Chief Justice? Thank you, Chief.
It's already 3:30. The court will have its en banc session also tomorrow. So we suspend the hearing today and continue on June 9 and 16, 9:30 in the morning. Attorney Marife, are there any other matters?
There are no other matters, Your Honor.
Please adjourn this. There being no other matters, the court hereby adjourns this en banc session. Thank you.